SJC-08464, Commonwealth v. Charles E. Robinson.
Okay, Attorney Krosky.
Good morning, Your Honors. I bring to the court no thorny legal issues this morning. Simply put, I just want to finish the mission that I was assigned back in 2001. As this court knows, I've already filed and argued a direct appeal after a hearing in front of Judge Botsford in the master's hearing. I fully expected when we had the direct appeal that we would be remanded back to complete the competency hearing that we had a number of false starts with in front of Judge Nickerson. Basically, what had happened, I think the court is pretty well aware of the facts of this case. It is pretty much fact-driven.
Mr. Krosky, can I get to the standard of review? Because we have two decisions by the motion judge, right? So I know you tried to get the hearing in front of Judge
Right.
Nickerson, and that
Yes.
didn't happen because of competency issues. So now we have the second time go around in front of a different motion judge. The motion judge makes two decisions. One is not to have a hearing,
Right,
and then the second is to deny the motion.
right.
The first decision the judge makes, not to have a hearing, is that an abuse of discretion?
No, yes, I think it is at this point.
No, is that under an abuse of discretion standard?
Oh,
I'm sorry.
I think the way we're here now is under a plenary review under 233, so I think we should be here in any event. But basically, what had happened with the second
Can you explain that?
judge.
I don't understand what you're saying. Plenary review, not abuse of discretion? I thought the decision
abuse-
whether to hold an evidentiary hearing
Well,
was subject to an abuse
On
of
the
discretion
abuse of,
standard.
on the abuse of discretion, I think it's a ineffective assistance, strike that, the competency hearing, the standard is if there are no other alternatives and no other alternatives to review. And I think in this case, given the Commonwealth's position with their own psychiatrist, Dr. Kelly, that it is an abuse of discretion not to allow us to continue the hearing, that we commenced under pretty tough circumstances. We had, I think, 3 false starts. We actually had 2 days of hearing, and the defendant, Mr. Robinson, was not capable of completing the hearing after an evaluation by a court psychologist.
Can I ask, sorry.
I'm sorry, please go, Chief.
I was just going to ask, what would have been gained from a hearing if you've got the affidavits from the experts? And so if the trial judge, the motion judge took a look at everything and said, I've got everything I need.
Well, I think we have to go back to Judge Nickerson's last ruling. I think it was kind of an ambiguous use of language. I understood what he meant because we had a sidebar hearing. Unfortunately, it was not recorded by the stenographer because it was off the record.
But Judge Gilday wouldn't have been
Pardon?
bound by anything that Judge Nickerson would have said.
What was that, Your Honor? I'm sorry.
Judge Gilday, who decided not to have the evidentiary hearing,
Right.
would not have been bound by anything that Judge Nickerson said.
I understand that, but I think the equity in this situation goes back to the history of this case. It's a fact-driven case at this point. There were 3 hearings that
No,
we
I understand,
scheduled.
I think, your argument on the equities and why you would like to have had an evidentiary hearing. I guess I'm wondering, back to the Chief's question, what would the evidentiary hearing have gotten to Judge Gilday
Well,
that he didn't already have from the affidavits?
exactly. There are 2 hypotheses that are in equipoise. One is the fact that we had 3 psychologists evaluate or psychiatrists actually, evaluate Mr. Robinson. Then the Commonwealth hired Dr. Kelly, and Dr. Kelly's evaluation was ambiguous. In fact, the equipoise is that there was some doubt in his mind as
You might be overstating that. He basically says you could look at it both ways, but he's definitive that he's competent. I don't know if that's a little overstated, Mr. Krosky.
I don't
it
think,
was
in
ambiguous.
fact, he reviewed everything. He had the Bridgewater State Hospital records. He had 3 evaluations from 3 of my psychiatrists. In the end, what he said, the Bridgewater State Hospitals, and records were voluminous because he had spent half the time since I came on the case till today in Bridgewater State Hospital. So there's 6 inches of records, and he said they are problematic. That should have been fleshed out in a hearing. Also, he said the colloquy in the lockup and the 5th day of trial was problematic as well, and it could be subject to interpretation.
So let me ask you the second standard review question. So we have the 2 decisions, right? One is to not have a hearing, and the second is the decision on the merits by Judge Gilday. So assuming, for the sake of argument, the standard review for the decision to have a hearing is abuse of discretion, the second decision is de novo? That's your argument, basically?
Yes.
Because he did not have a hearing, so now we do the same thing he could have done. We have the records
But
in front of
I
us.
fully expected we would have had the hearing, given Judge Nickerson's, if Judge Nickerson was in the
Let's
case.
get back, but do you argue the standard review is de novo for the decision on the merits?
Oh, yes, that was Judge Nickerson's decision, because Judge Nickerson was concerned with the competency of Mr. Robinson to participate in the hearing on the competency during trial.
But I think
So
that,
he wanted another evaluation.
just because you know how fluid this is, obviously, and I think as Justice Wendlandt has stated, the Nickerson decision, that ship has sailed. We're focused on what Gilday did, correct?
I understand that. I suggest that, that he was in error when he said that there was no controversy arising from the evaluations of Dr. Kelly and Dr. DiCataldo. I suggest that when you look at the record and equipoise, it should have been fleshed out. There's no ifs, ands, or buts about it, Your Honor. There was a competency hearing right after trial. As you remember from the direct appeal, and when we argued this case, and that there was always a question of competency after the case, but that's not the guidance. The guidance is what happens during the trial, and we have, as Dr. DiCataldo pointed out, something that you never get, a colloquy where under Chapman, the attorney should have brought that to the attention of the judge.
And that's why you keep on saying equipoise, because I know
Right, the
you don't use
equipoise.
that in normal conversation, nor do I. But you're quoting the Chapman standard,
And I think
right?
that Judge Gilday, in reviewing that, should have taken that into consideration, and as a matter of law, he didn't, and we should be allowed to go back and
Because
flesh-
we have 2 qualified experts. You may disagree with what Kelly came up with, but we have 2 qualified experts. He says Kelly versus DiCataldo. That's a decision trial judges make all the time, correct?
Well, he had an
So
affidavit.
under abuse of discretion, that'd be difficult
Under
to
it
say
says-
it's an abuse of discretion.
Under abuse of discretion, I suggest that when the Commonwealth's expert says the hospital records are problematic, the colloquy is subject to interpretation. I think I suggest it's an abuse of discretion not to find out what that interpretation is from Judge Kelly, from Dr. Kelly, rather. Dr. Kelly just says it's subject to interpretation. Well, what is that interpretation? Can I, if after cross-examination as a psychiatrist, say that interpretation favors the defendant? We don't know that, so I think that I suggest, and I know in my own experience, that was so ambiguous that it is an abuse of discretion for the judge not to follow through.
If we find abuse of discretion not to have a hearing, we remand it. What's this hearing going to look like 25 years from the date of the event?
The record's pretty clear. I don't think there's a problem there, and I thought that myself. This is 23 years removed from that colloquy, but the record is clear. The record doesn't change. The record is not abstract. The record is discrete.
But does that suggest there should be no evidentiary hearing then?
Pardon?
Does that suggest there shouldn't be an evidentiary hearing?
There should be.
But if the record's clear, what are, you see, I'm still troubled.
When I say clear, if Dr. Kelly looks at the record and I cross-examine him on what he's seen on the record, then we can find out what that subject to interpretation means.
See,
So I don't think we're prejudiced by the time in this case, because there are progress notes on Mr. Robinson over the years. So we know discreetly and in real time, what he was going through.
It's a snapshot, though, right? We're really looking at a snapshot of his mental state
But there were
at that time.
evaluations, we've had evaluations since day one and they've all been used by the subsequent and follow-up experts. Dr. Rosemarin filed a lengthy report. That was followed up by Dr. Ebert and Dr. D. Cataldo. Dr. D. Cataldo has spoken to witnesses, he's spoken to prior counsel.
What do
So-
we do with the fact that prior counsel did not submit an affidavit?
Well, he was summoned at the time by the Commonwealth, so I think he was about to take the stand when we found we couldn't go through with the hearing. And not only that, we had for the first time in my experience, and I've done a few of these, the first time in my experience, we had mid-trial, in real time, contemporaneous, what was going on, a colloquy between defense counsel and the defendant. And it's clear that Chapman, which came down, Chapman 1 and Chapman 2, that at that point, that the defense counsel should have notified the judge. In fact,
But before you leave that, so is the failure to have an evidentiary hearing where you call the defense counsel? I mean, the two people who knew the mental state of the defendant best at the time of trial, which is the relevant time period, correct?
correct.
Are Dr. Montgomery and the defense counsel, right? They're the only people who can.
I'm
Was
not
there
sure-
was there a Commonwealth expert in August of 2002? This is an August 2000 trial, right?
No. The defense counsel at the time had taken a first-degree murder to trial from February to August. Within 6 months, he had a trial, and at no time was there ever any question in defense counsel's mind that he should have had a psychiatrist on board. And one of the reasons is, and the
But
record is
you're
clear,
confusing me.
that he never spoke with the defendant between the time of his assignment and the time of trial.
Right,
And
but
that's clear on the record.
No, I understand that, but I'm trying to understand, it really goes back to the Chief's original question, which is, what more would we learn in an evidentiary hearing? And the two people who are most knowledgeable about his mental state are defense counsel and Dr. Montgomery, right?
Doctor, I'm not sure who
She did the evaluation when he was sentenced.
that was, there have been so many doctors. Dr.
But-
Montgomery was at
but
Bridgewater
they're the
State.
ones who
That was
were-
afterwards.
I know, but they're the ones who actually are I mean, these other doctors are 6, 7 years later, and they disagree with each other.
I think Dr. Rosemarin was on less than that, maybe 3 years.
I don't know, I thought it was like 5 years, but I could be wrong.
Well, he was involved early on, but I think the main evaluation might have been done at 5 years, but I know he was early on. What happened was I didn't get any money for a psychiatrist at
But
first.
Can I just ask, so if I'm, and I may be off base, but do you see any evidentiary value of having Montgomery or the defense counsel? Because they're the people, again, his mental state 5 years later, after he's been convicted and been in Sousa, is different from what it was the day he is convicted.
Sure,
right?
under the law, we have to show that post-conviction could be related back to.
I understand that, but
to pre-trial. So we would have to take into the fact finder, the judge in the motion hearing would have to take into consideration facts and circumstances. The Commonwealth in its brief points out that the mother and the girlfriend, the mother of the child, were
See,
not expert
I'm trying to be
witnesses.
helpful to you, but I'm maybe not getting it across. To me, you seem to have an uphill battle when you're dealing with dueling experts who interview the defendant 5, 7, 9 years later.
Right.
But you do have two people, the defense counsel and at least one mental health professional, Dr. Montgomery, who actually are sort of conversant with the defendant's mental state at the time. Now, the defense counsel says, nothing doing, I'm going forward with the trial. So I'm not sure that's going to be helpful for you at the evidentiary. And Montgomery is opining that he is competent. But those are the only two people who know anything.
I'm not sure where Dr. Montgomery comes in pre-trial. There was never any kind of psychiatric evaluation.
Montgomery was able to do a mental health evaluation of your client the day of or the day after the verdict, very contemporaneous with the trial. And she opines competent.
I'm not aware of, I know that there was an evaluation done at Sousa Baranowski.
Assuming that I'm correct on the statement of the facts, what is it that an evidentiary hearing would help you prove?
It would enable a fact finder to make a discrete finding of fact that at the time of trial, Mr. Robinson, and I know that this would be the outcome, that Mr. Robinson was not competent to participate in the trial of his case in the Commonwealth versus.
You want to be able to drill down into the Kelly opinion.
Absolutely.
In a
It has to be done, Your Honor.
In an evidentiary hearing. You want to
Has to be done.
cross-examine Kelly.
I am unequivocal on my belief that to flesh this thing out, Dr. Kelly's testimony
And
has
that's
to be defined and clarified. Because it's too ambiguous at this point. Interpretation, problematic. I suggest a motion judge can't say, well, problematic, so what, and just discard it as superfluous. It's not. This is a first-degree murder trial where under Chapman 1 and Chapman 2, the defendant was making all kinds of inappropriate remarks, meaning they weren't relevant and they weren't germane. I was with him through 6 evaluations. Judge Nickerson had him evaluated by a court clinician and had me go in to observe myself because there were all kinds of things happening during the course of the maybe 12 times we're in court in Barnstable. 2 times I remember distinctly that Bridgewater said we can't send him down because he's not mentally capable.
But again, this is all after trial, right? This is after.
But that's all relevant because that goes to Dr. Kelly's, he didn't follow through and give Judge Gilday his interpretation of what problematic is.
They didn't feel he needed it, but I guess we'll address that.
I disagree, Your Honor. I just think there's too much up in the air, given that prior to trial, the mother and the girlfriend had given all kinds of information about this really odd behavior, and it was not taken into consideration by
But
defense counsel.
He had that, right?
Pardon?
Didn't
That's
the
all
motion
part of the
judge-
package
yeah,
that we sent up here.
Okay. Is there any other, are there any? Okay. Thank you very much.
Thank you.
Okay, Attorney El-Khoury.
Morning. May it please the court. Rose Ellen El-Khoury for the Commonwealth.
Can I ask you the standard of review so we get our bearings?
Of course,
So we have 2 decisions. I'm going to start the same way I did with Mr. Krause. We have 2 decisions by a motion judge.
yes.
One is to not have a hearing, and the second is a decision on the merits.
Yes.
The decision not to have a hearing, that's an abuse of discretion standard, correct?
Absolutely.
Okay. The second decision on the merits, because he didn't have a hearing, because he wasn't the trial judge, that's de novo, correct?
Well, the Commonwealth maintains that motion judge's denial of a motion for new trial is an abuse of discretion standard. However, we fully understand that where the motion judge, as here, was not the trial judge, this court is in as good a position to review as the motion judge
Right.
was.
So we have a motion judge who basically has 2 conflicting psychiatric reports in front of him.
Yes.
He picks one.
He reviews both. He reviews all
okay.
the materials in front of him.
Okay, I'm short-circuiting this. He credits Kelly.
Yes.
Inferentially doesn't credit DiCarlo's report. The Chapman case says,
Yes.
and I'm not used to the equipose,
Yes.
when it's a jump ball, you lose.
If it was a jump ball, Your Honor would be absolutely correct. When all the evidence...
Why wasn't this a jump ball when we have 2 conflicting experts?
Well, because it was more than just 2 conflicting experts. The motion judge's decision was very thoughtful. It examined every piece of evidence submitted by the defendant in support of his competency claim. So that was the 2 affidavits from the defendant's mother and the mother of his children from 2001. That was the transcript of the conversation between trial counsel and the defendant from August 18th of 2000, and that was the report submitted by Dr. DiCataldo that was submitted, I believe, in July of 2018. So the motion judge reviewed those 4 submissions. The motion judge also reviewed what was submitted by the Commonwealth, which, as this court has already pointed out, included the evaluation by Dr. Montgomery from August 22nd of 2000, the day after the defendant was convicted. It included the report of Dr. Kelly. It included the affidavit submitted by Judge O'Neill, who presided at trial, stating that there had been no records of any, he recalled no unusual outbursts or behavior, which is a factor that this court can consider. And looking at the transcript supports that recollection, that the defendant did not display any of the sort of behavior that is typically associated with the kind of psychosis that the defense expert claims that the defendant was experiencing at the time of trial. So the motion judge reviewed all of this, and he went through and he discounted the affidavits from the defendant's mother and the mother of his children. He said, not only are these sort of remote in time, but these are also submitted by individuals who have no experience evaluating a person's competency. And under, I believe it's Goodrow, that this court has held and supported a motion judge's decision to sort of set those aside, because those are...
Using the de novo standard in the Chapman language, what do we do with Kelly's report that says that the colloquy between the defendant and defense counsel is problematic, is open to interpretation, and his Bridgewater State stays are problematic?
Well, I think I would respectfully submit that what Judge Gilday did in this situation was correct. He looked at that and said, well, this is, none of this even starts until the defendant has served the first 9 months of a life sentence. So how
That's not true for the jail discussion between counsel and the defendant, right?
Yes, but...
That's the big...
Well, the Commonwealth would, to its own sort of embarrassment, remind this court that before it right now is a very good example of 2 differing interpretations of the transcript. As the defendant pointed out in his reply brief, something that the Commonwealth read, going through the transcript for the first time in February of this year, there's a reference made by trial counsel to documents that were sent to Mr. Robinson. And having no context for any other Mr. Robinson in this case, it was the Commonwealth's assumption that he was referring to the defendant. And in the reply brief, the defendant is arguing that that was actually the same last name as the head of probation at this time. So when you take a conversation and you reduce it to a transcript and you're examining it more than 20 years on, I would say it's very easy to subject it to differing interpretations.
Well, but does that mean you should have had an evidentiary hearing where that lawyer is brought in to say, okay, he's babbling incoherently, but I concluded I concluded what,
In Dr. DiCataldo's report, he does base some of his determinations on conversations that he had with trial counsel. I believe he spoke with trial counsel, I want to say 2 days before he drafted his report. And the Commonwealth would also point out, as the motion judge took note of, as this court has already noted, there was no affidavit submitted by trial counsel in this case, and the record indicates that as late as 2018, he was still engaging with this case and responsive to questions. The Commonwealth would further point out that there was no affidavit submitted by post-conviction counsel detailing the efforts to secure any kind of affidavit from trial counsel and trial counsel's refusal to cooperate. So, as everyone is aware, silence and a lack of evidence from an available and expected source of information can be considered and does cut against the defendant's argument here.
In Chapman, was it a battle of the experts, or was it differently, it had a different status?
I would not categorize Chapman as a battle of the experts.
Yeah, well, didn't it, the defendant came forward with some experts, and then the Commonwealth stood on the trial counsel's affidavit?
Yes, I believe that was the case in, I believe it was Chapman, I'm confusing Chapman 1 and 2, but one of the Chapmans, I believe that was the posture.
Can I ask one follow-up? And I should know this, but I don't. So was the defense counsel was the defendant planning on calling the defense counsel at this evidentiary hearing? Is that in his submission or her submission?
In Chapman or?
No, this case.
In this case. In this case, there had been the beginnings of evidentiary hearings prior to the 2011 order, in which the judge basically stated 4 things, and among them, it was that we're not taking any action on these prior motions. The defendant may file an amended motion for new trial, which clearly sets forth the factual and legal basis for relief. The amended motion should be accompanied by either a detailed supporting affidavit from an appropriate mental health professional or an affidavit of counsel with a clinical report sort of outlining the mental health posture at this time. And this is the one that the Commonwealth discusses, at length in our brief, and it's on page 103 of volume 2 of the record appendix. That in the event the court conducts a hearing on the amended motion, said hearing will commence anew with reliance upon the testimony and arguments presented on past occasions. Without reliance. That's a big difference, and it really matters. Basically, this defendant was offered the opportunity to begin anew, and he took his time in considering what arguments he wanted to raise. And in 2014, he filed his first amended motion for new trial that dealt only with the competency issue.
Yeah, mine's a narrow question, and you may have answered it, but when the defendant's arguing for an evidentiary hearing, is one of the bases for it that he needs to call the defense counsel, or is that not part of the request for the evidentiary hearing?
Where the record stands as it is at this time, with no affidavit from counsel and no affidavit from trial counsel and no affidavit from post-conviction counsel detailing the efforts to get in touch with trial counsel, the Commonwealth would argue that that is not relevant. The defendant on his filings offered a number of supplemental reports for this court's consideration that were not before the motion judge, and even at that point did not submit an affidavit from trial counsel or post-conviction counsel discussing whether or not trial counsel would be an available participant in an evidentiary hearing. If there are no further questions, the Commonwealth would request that this court deny the defendant the relief requested and deny him a second round of review under 33E and rest on its brief.